now. My name is Mike Solomon. There's a law firm of Solomon, Steiner Peck. I almost said my own firm's name. There's an outline on keeping your assets in your Bloodline Trust, and hopefully you can all see the PowerPoint on the screen. After the seminar, we'll also send you a hard copy for your files. We've done this seminar quite often, and people find it very useful in their planning. So I'm going to talk a little bit about that, some general tax planning, and I will try to take questions as I go along. For some reason, I can't get the video going, but that's okay. I guess I'll just not worry about that. Okay, so I'm going to skip to the beginning of this. As soon as there we go. Let me start at the beginning. It's a little slow. Okay, estate and income tax planning for 2021. And if you have questions as I go along, put them on the chat, and I'll try to answer them as I go along. So let me talk about the law as it exists today, as of this Tuesday, September 21st. Right now, the exemption per person is $11.7 million. So a married couple can shelter almost over $23 million. So for most people, this is not an issue. They don't have to worry about estate tax planning. The Ohio state tax disappeared a long time ago, so that's old news. And also, there's still the step up at income tax basis rules that are still around. And so that means, if, for example, if you bought Google stock at $1 and you passed away, whoever inherits those shares gets your basis of the value on the date of your death. So generally no income tax when they inherit your stock and you turn around and sell it. Now, when I first did this seminar back last year after the election, I had thought I would be able to tell you exactly what the tax law was going to be because I thought it would be passed by now. And right now we're still up in the air of what's going to happen. There's been now the House has started to work a little bit on it, the House Ways and Means Committee, and Biden has his thoughts about it. The Senate Finance Committee, I haven't heard much from them. But right now it looks like the idea would be that they would raise the individual income tax rates for a single person earning $400,000 and married $450,000 up back to the Clinton era, 39.6%. There's now talk they're going to lower the federal exemption from the 11.7 million to approximately 6 million. Now, there was talk initially that Biden was going to reduce it to $3.5 million a person, but that didn't happen. At least that's been dropped, apparently. And then the other big change for wealthier people is they're not going to raise the tax rate. It's 40% once you get above the exemption. Right now it's 11.7 million, but it may be down to 6 million a person. But they're not going to raise it to 45%, which is what they were going to talk about. They're also, it looks like they've cast aside, there was going to be a tax on your assets, no matter, on your death. In other words, they were going to get rid of the step up in basis rules and tax you on death on that capital growth. So for example, if you had bought Google for $1 and it grew to $1 million, on your death, you would pay the tax on all that growth, income tax on all that growth, not an estate tax. There was probably going to be an exemption so it wouldn't catch everybody, and that apparently has been cast aside. As far as I know, they're still going to eliminate like-kind exchanges for larger deals. And right now they're talking about raising the capital gains rate from 20%, the maximum, to 25%. Now, that's plus if you have a large capital gain, you're probably going to owe the 3.8% investment income tax. So, you might get up to 28.8% plus state income taxes on your capital gains. But note that they have gotten rid of the proposal to tax capital gains at the maximum income tax rate of 39.6% for very large income earners. At least that's from what I've been able to tell. Of course, no one really knows. There hasn't been any official tax legislation introduced. So you should keep an eye on it, an eye out on all of this, because it's still also not known whether any changes will be prospective or retroactive. In other words, I've seen some people say, and I haven't seen this in writing, but someone told me that the House Ways and Means Committee said their changes are going to be effective September 13th when they introduce them. So the change of the tax rates and those sort of things. I've seen other things that it won't be effective until next year. One way or the other, they've got to pass something in the next month, because once we get past October, nothing happens really for the rest of the year, typically. So that's where we are with proposals. So you just have to keep an eye on it. If anything has ever passed, we'll definitely do a seminar on it. So now let me talk about non-tax planning. And we talk about this topic a lot because I think it's really important, and many of my clients want this once they hear about it. Most times you have an estate where, let's say and I'm making up an example here, Mary has a house and investments totaling $500,000. She just wants it split evenly among her children. And she wants to make sure that everything she's built up for her family are inherited by her grandchildren as well. She doesn't want her in-laws to get the money, not necessarily because she hates her in-laws. She just, she built it up. She wants it to pass on to her children. Now, many people think they already have this plan in place. Many people say, look, my last will and testament or my living trust says it goes, they use the Latin word per stirpes. If my child dies, it goes to their children. But that only happens in most documents if your child predeceases you. In other words, you have a son and he passes away. Most estate plans provide that your son's children will be inheriting your assets. But most plans don't, most times, hopefully, your children outlive you. So with that in mind, most plans provide that upon your passing, your assets go outright to your children, or maybe it's held back until they hit a certain age, maybe 30, 35 years old. But eventually your children get the money. Once they get the money, it's theirs. It's governed by their documents. And then a lot of bad things can happen. So for example, in my example, when Mary passed away, 1/4 went to her son, Frank. Frank inherited the money. He combined it with his wife's money. Then later on, he got a divorce and Mary got some of that money. The other 1/4 went to her daughter, Lisa. Lisa passed away. Her will says everything to my husband, Bob. Bob remarries, and he might have children with a new marriage. Maybe he likes his new wife better, whatever. The money might end up going to Bob's new wife, might go to Bob's other children or children of Mary. Either way, of Lisa's children, it won't go to Lisa's children, it might go to somebody else. Either way, Mary's grandchildren might receive nothing in that plan. Another 1/4 went to Harry. Harry was a doctor, had a major malpractice lawsuit against him, and he can risk losing his entire estate to creditors. And finally, Larry is a nice guy, but he spends the money faster than he gets it. So he gets his inheritance from mom, spends it quickly, and then he's still poor after that. He regrets it, but it's too late at that point. So how do you solve a problem like that? Well, these slides are very slow when I click on them, so I apologize. So, you have divorce, death, lawsuits, easy spending. These are, these are all problems. Also, you can have a double tax. Now, that's not going to happen that often right now. For example, if Harry had a large estate, it was like $15 million, and he inherits more money from his mom, that just increases the size of his estate. Eventually, he's going to have to pay estate taxes. So, it's something you have to consider, all these issues. Now, how can you solve that? You can't solve this with a last will and testament. Because I said, most wills just say on death, it goes outright to my children. Very few wills nowadays have what's called a testamentary trust. Inside the will, it says, on my death, the assets are held in trust. The reason we don't do that a lot in Ohio is because if you provide trust language in your will, in your last will and testament, then you will have a probate forever. You'll have to report to the probate court. So most people try to avoid that in Ohio. Not all states have that as bad as Ohio, but Ohio does. So usually you don't put in trust-like language in a will. You just say the money goes outright. Joint accounts or beneficiary accounts, those don't help you either. If you provide on your IRA or a bank account or a brokerage account, TOD to my child or a joint and survivor to my child, once you pass away, it's theirs. You can't put any restrictions on it. There's no way to put restrictions to make sure that money eventually goes to your grandchildren. And a typical living trust doesn't have that either, because as I said, most living trusts provide that on your death, your assets, maybe they'll be held back to age 30 or 35, but they go outright eventually to the children. You've got those same issues. Any questions before I go on any of this? Okay, so let me go to the next slide. So the way we approach this is what we call a bloodline trust. As I always mention in all these seminars, that's a made-up word. It's a word to kind of describe it. You won't find that in the tax code. They don't have bloodline trust in the tax code, but it's a trust. The concept of the trust is on your death. Now, by the way, this can be a revocable trust or an irrevocable trust. Typically, it's revocable. I mean, it's part of your estate plan, so you draft it so you can modify it from time to time if you change your mind. You can set up an irrevocable trust where you give away money now and have these same sort of provisions in there. So with a bloodline trust, the concept is it keeps the money eventually in the family. You can include adopted children, grandchildren. You could have non-family members if you want, but you get to choose the people you want to inherit your assets. And typically, we keep it in the family. So it goes to your children and then your grandchildren. We can have your child be his or her own trustee. We don't need an independent trustee. So they don't have to ask someone for the money. You can still get all these protections I'm going to talk about, all the bloodline protection, even though their children are their own trustees. However, if you have a child like Larry, he's not good with money. If you make him his own trustee, even though the trust document is going to say, Larry, only take money out from this trust when you need it, he can ignore it. You've passed away. You're dead. You can't stop him at that point. And the government doesn't care about this trust. So there's no one there to stop him from abusing the trust. So you need to, at that point, consider whether you want a third-party trustee. That could be another family member, another child, though that has a dynamic. Do you want child number one being the trustee for child number two? That could cause some rift in the family. You could use a bank or a trust company. The disadvantage there is they're going to charge you money. They're going to charge you around 1% a year to be the trustee of that trust. So there are pluses and minuses, but you need to look at it very carefully. Now, you can keep the assets. Now, once you pass away, these assets are now in the trust for each of your children. Let's say child number one, he's the trustee of this trust, your son, let's say. The assets are in there. They're not marital assets. So if he's married and gets divorced, his soon-to-be ex-spouse has no claim on those assets. They cannot get those assets. It's protected from divorce. Number two, you provide in that document, when my son passes away, the assets go to the grandchild, if that's who you want it to go to, your grandchildren. Now, typically we put in this trust, if we can, if everyone, is we give your child the right to reallocate the assets among his children. And remember, this trust becomes irrevocable on your death. So on your death, if your son inherits the money, and the default typically is that whatever he doesn't use on his death goes equally to his children. Well, maybe later on after you've passed away, one of his children is not a good person, a rotten child. Or maybe one of his children, is the next Bill Gates and doesn't need this money, but another child's a social worker and they need the money. We give your son, in my example, what's called a power of appointment to reallocate your inheritance among his children. We typically don't give him the right to give it to anybody he wants because it kind of defeats the purpose of the bloodline trust. But we give him the right to reallocate it among the children so he can adjust the plan if things change as he goes along. Again, if you have any questions, feel free to put them in the chat and I'll take a look at them, or the Q&A. I guess we have that also. Either one. Number 6 on this list, it protects your assets from creditors. No, except for the IRS, creditors cannot get this. State of Ohio IRS, I should say, both have access to it. But this law, the Ohio Trust Code, was modeled after the Uniform Trust Code, and other states have done that. There is a state, I can't remember if it was Connecticut or New Hampshire, which modeled their law and protected it against creditors. And the beneficiary was a sexual predator, so a really horrible person. And one of the people that he imposed himself upon wanted to get a crack at his trust assets, and they couldn't. The court said, we'd love to do it because this person's despicable. They didn't really say that, but basically. But we can't because the law says these assets are protected from creditors. So it's another benefit. And then number 7, if depending on the estate tax laws, you can draft this trust so it's not part of your child's federal estate tax. Now, there's actually other planning that we're doing now for clients because most of our clients nowadays don't have a federal estate tax problem, and especially their children probably don't. So we put some flexibility in this document. So what we do is, rather than say the assets that your child inherits that are in this bloodline trust, we design it so for federal estate tax purposes, it's taxed in his estate. that means he gets a step up of income tax basis. So again, you bought the Google stock for $1, it grew to $1 million. On your death, it won't goes into this bloodline trust. It gets a step up in basis. So the Google stock can be sold or not, but its tax basis is $1 million. There's no income tax in the first $1 million of the sale. Let's say they make a new investment. They sell the Google and they buy some other high-tech stock, and it grows to $10 million while it's in this trust. If I was worried about estate taxes, I would design this plan so it would not be taxable in the son's estate for estate tax purposes. All 10 million would be exempt from federal estate tax. However, if I say to myself, well, the estate tax exemption is high and this son is not going to have a federal estate tax, then I'll try to design the plan so those assets are includable in his federal estate. So when the son dies, he gets a step up in basis on that $10 million investment and wipes out all the capital gains. Now, the other problem is, of course, we don't know what the future is going to hold. Maybe your child makes a ton of money. Maybe they change the tax law to make it more confiscatory for estate taxes. So we also put a provision in our document that allows us to change whether it's taxable in your child's estate or not, depending on the facts. So that's some more flexibility. So there's one question here. Someone asked, why would you ever use an irrevocable trust versus a revocable trust? That's more of a estate tax planning issue. If you have a large estate and you want to use some of your exemption now, then you can make a large gift into an irrevocable trust. Means you can't change it at that point. Get that out of your estate, the growth out of your estate, I should say. And then you put all these provisions in there that I'm talking about. But many people don't need to do an irrevocable trust when they start out. Any other questions? Okay, let me go on. So now the next question is, how do you protect the assets on remarriage? And this goes to your level. So let's say you're married. Story of Bob and Jane. I'm going to use this story. Bob and Jane, second marriage for each. They each have children from their first marriage. Their second marriage may last as long as the first marriage. Who knows? But they've been married a long time. And I'm going to use this Bob dying first in my example. Bob wants Jane to benefit from all the wealth he's built up over the years, but he wants to make sure that on his death, his assets go back to his children, not to Jane's children. Well, if Bob just does a simple will, Jane inherits the money, and then on Jane's death, what's going to happen? Her will's going to say everything goes to my children, and Bob's kids get nothing. And I've had that happen. The kids come in later and say, Dad couldn't have meant this, and they're right. Dad didn't mean it. He didn't have the right plan. So the right plan is a marital trust. So what you would do is, Bob would provide for a marital trust. It's revocable while he's alive. He can change it, but on his death, it becomes irrevocable. And then it has much of the provisions of the bloodline trust. The income and the principal is there for his wife, but on his death, whatever's left in that trust goes back to Bob's children, not to Jane's children. And that's going to be important for a lot of people. Now, you have to decide who's going to be the trustee of this trust. If you make Jane the trustee, remember, it's very difficult. The government doesn't monitor this. The only people who can complain at all are Bob's children, and it's a tough battle. Is Jane taking too much money out? Is she allowed to take this amount out? Those sort of battles are going to be tough. So you might want to think about having either a co-trustee with Jane or an independent party as a trustee. But there's no right or wrong answer to that. It's just one of those things that you have to think about when you do your estate planning. Now, I'm going to mention the Ohio Legacy Trust because people are interested in this document. This is, very few people should do this. I'm literally a handful. An Ohio Legacy Trust was adopted a number of years ago. It used to be under all states almost in the country. The idea that you could not set up a trust for yourself where you benefit from the trust and exclude those from claims of creditors. You just weren't allowed to do that. And over the years, because many people were parking their money offshore trusts, many states, I think around half now, have provided for legacy trust where you can set up a trust. It becomes irrevocable. You can't be the trustee of the trust, but you put your assets in this trust, You can be a beneficiary of the trust, but it's protected. It's protected from any of your creditors. It's not protected for spousal support. So if you're married, you can't do this now, put it in the trust and assume it's going to be protected against your soon-to-be ex-wife. You can't protect it from child support, and you can't protect it for transfers with specific intent to defraud creditors. What that means, if a creditor is already threatening you or knocking on your door, this will not help you. This trust will not help you. But other than that, this is if you're worried about creditors, if that's a major factor, then this might be a tool. You can't be the trustee, but you can control investments and you can veto distributions. So let's say you have a third party be the trustee. Some people, husband will use a spouse. I don't recommend that, but you can use a third party, a trustee, maybe a trust company, but you can control the investments and you can veto distributions. The reason that's important is that in case you're going to name yourself beneficiary, your spouse, and your children, you can't say, give me the money to the trustee, but you can stop the trustee from giving the money to anybody else. Now, the trustee is going to know what to do. They're going to know that if you need money, they're going to give you money. But that's how it gets protection. So it's a tool very, very few people should use. Most people do not need that tool. Now, the other topic I want to talk about, and I don't have a PowerPoint for that, so I'm going to leave it on the screen right now, is dealing with your IRAs. I meant to put that in the outline, and I forgot. So, they changed the law back in 2020 with IRAs. As you know, they eliminated the ability to stretch IRAs except for limited situations. The limited situations are a spouse, your child who's under age 18, but only until they're age 18. And then certain other situations with a disabled child or a disadvantaged child, or someone who's less than 10 years younger than you. And let me explain what that means. So under the old law, what we would do many times is with a client who had sufficient assets, have their IRA paid to their children or grandchildren. So on the death of grandpa, let's say you had a $500,000 IRA, it pays to the grandchild or a trust to the benefit of the grandchild over the grandchild's life expectancy, which at that point in time could be 50 or 60 years. So it stretches out over 50 or 60 years. The tax deferred growth is immense. So a couple of years ago, Congress finally got tired of this. And so they passed a law in 2020 that said, basically, on your death, except for, as I said, certain situations, it has to empty out in 10 years. That's both a traditional IRA and a Roth IRA. So the stretch IRA is no longer available except for a spouse. So if you have it go to your spouse, you can qualify for a stretch IRA. You can have it go to someone who's less than 10 years younger than you, and they'll pay out over that person's life expectancy. So for example, if you have no children and no spouse, maybe you have it go to your brother or your sister. They're hopefully within 10 years of your age, and then they can stretch it out over their life expectancy. And then they have certain situations, if you have minor children, not grandchildren, they'll let it come out over the life expectancy of the grandchild until that grandchild reaches age 18, and then all of a sudden it has to come out over 10 years. And they have, again, if you have a disadvantaged child, special needs child, they do provide some flexibility there. The important point on this also is many trusts, many people still have their IRAs paying into their living trust that were drafted prior to 2020. And their documents typically will say, for various income tax reasons, will typically say the minimum required distribution must come out of this trust annually. So for example, if you passed away and your required minimum distribution the first year was $10,000 and it was payable to the trust, the $10,000 would go into the trust and would then have to come out of the trust to the beneficiary. The rest of the IRA, let's say the $1 million you have in the IRA, stays in the IRA. However, now with the new rule, changes the required minimum distribution to a 10-year window, that IRA will pay into the trust and empty out of the trust within 10 years. Now, for many of you, that's fine. But for many of you, you don't want that IRA to empty out. You're afraid that whoever's going to inherit it will spend the money unwisely, and you'll decide that you'd rather have that money stay in the trust, even though the trust has a higher income tax bracket. So there's no right or wrong answer, but if you have pre-2020 trusts and you have IRAs paying into the trust, you need to look at those documents to make sure they do what it is you want. Now, that's all I'm going to cover today. Did anybody else have any questions? If not, we have a seminar coming up, I believe, next week or the week after on Medicaid planning with Lori Steiner, and you'll get an email on that if you haven't already. So I'll take any questions. And if not, please have a good day and be on the lookout. And we'll send this outline out to you. And if you have any questions you don't want to ask now and you want to email them to me, feel free to do that also. Thank you very much.